Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This weekly pod will be about 10 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is K.E. Liggett versus Lou Realty, Inc., a fairly recent appellate division first department case. First, the context you need to understand today's case. So there's more than one type of rent regulation in New York City. Among others, there are rent control and rent stabilization. Rent control is a completely different system from rent stabilization, but people get them mixed up all the time. There are only 16,000 rent control apartments left. That's really not a lot because there are over 1 million rent stabilized apartments. There are so few rent control apartments because rent control ended in 1971. So unless you've lived in your apartment since 1971 or are someone who succeeded to a rent control apartment by a family member or someone who was like a family member to you that you lived with in the apartment for a period of time, then you're not rent controlled. Rent stabilization applies to an apartment for a few different reasons, but one of the big ones is that the building was built before 1974 and contains 6 or more units. Therefore, when a rent controlled tenant moves out, there's no more rent control. But if the building that apartment is contained in has 6 or more units, then the building probably went straight from rent control into rent stabilization. The next thing you need to know to set the stage for today's case is that rent control and rent stabilization, these are not deals made between landlords and tenants. The deal between the landlord and the tenant is the lease. That's the contract between the parties. Rent control and rent stabilization are statutory systems created by the state legislature in Albany, and they're superimposed on the tenancy. Put another way, your apartment is never rent stabilized or not rent stabilized because you and your landlord decided that it would be or wouldn't be. You and your landlord, you don't have any choice. You don't get to decide. The apartment is either subject to some form of rent regulation because of independent objective factors or it's not. And that's the background you need to set the stage for today's case. Okay, I put a link to today's case in the show notes. One of the things that makes cases about rent stabilization so interesting is that a lot of them have fact patterns that go way back in history. In today's case, we have to go back over 20 years. So in the year 2000, there was a rent-controlled tenant living in the subject apartment. The rent-controlled tenant died and left a roommate in the apartment. The landlord sued the roommate. Now, the roommate said that he was a successor to the rent-controlled tenant, but the landlord thought that was a lie. Eventually, the parties settled this 2000 case between them, and the roommate agreed that he was not the successor to the rent-controlled tenant, and therefore the apartment was no longer rent-controlled. The landlord agreed, and the apartment went into stabilization, and the landlord gave this new rent-stabilized tenant a lower preferential rent. We talked about preferential rents in an earlier episode. So everyone lived happily ever after until that rent-stabilized tenant moved out, and then a new tenant moved in, and at that point, the landlord was treating the apartment as deregulated because of its rent level. So in 2021, landlord sues the current free market tenant in this apartment, and the current free market tenant said that they were rent stabilized because the rent level of the last rent stabilized tenant was wrong. Why was it wrong? The tenant's argument was that the apartment never should have moved from rent control into rent stabilization back in 2000 because the roommate back then and the landlord didn't have a right to make an agreement that the apartment went out of rent control because, as we saw at the beginning of the podcast, landlords and tenants can't make deals about the rent regulatory status of an apartment. And the lower court agreed with the tenant. But then the case was appealed and the appellate division first department reversed the lower court. It said, it was okay what happened in 2000. That deal was okay. Why? I thought landlords and tenants couldn't make deals taking apartments out of rent regulation. Well, the answer is that the appellate court found that the roommate in 2000 wasn't so much agreeing that the apartment was not rent controlled. Rather, the roommate in 2000 was agreeing that he didn't succeed to the rent controlled tenant's tenancy. So the rent controlled tenant's tenancy ended organically and the apartment became rent stabilized. What's weird about this case is that you don't really get to understand the court's reasoning until you read a footnote. What I just told you is basically in footnote number 3. So the answer why the court went the way it went wasn't really in the body of the case, which I think is a little strange. Anyway, this gives rise to a very interesting tenant takeaway. But first, housekeeping. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it's terrible legal advertising because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions. I might be answering listener questions on the pod, but not announcing your name. But I would love to say which New York City neighborhood you're from. In fact, I got my first listener question the other day. I'm going to try to put it together for an episode of the pod. If you like our work here, please send us a note and tell us you like our work. But the best thing you can do is give us mountains and mountains of stars. It's time for the tenant takeaway. Okay, today's tenant takeaway is basically that the exception proves the rule. At first blush, this case looks a little bit like it might be about an easing of the rule that landlords and tenants have no ability to contract in or out of rent regulation, but that's not what's going on. This is a very narrow set of facts, and the exception ends up emphasizing the rule, which is simply that landlords and tenants can't make deals deregulating apartments. Occasionally, you see a landlord say to a tenant, hey, if you agree that you're not rent stabilized, I will agree that you have a lower rent for the entire time you're here. And when you leave the apartment, then the apartment will be deregulated. That's still not a deal that anybody can make. That is not a deal that will be effective or enforced by a court. Any subsequent tenant can challenge that deal. And in fact, the tenant who made the deal can challenge the deal. It's not worth the paper it's written on. And the other thing you see is tenants will say, well, I guess I'm not rent stabilized because it says in big letters across the top of my lease that I'm not rent stabilized. That does not mean that you're not rent stabilized. It just doesn't. You might be rent stabilized. You might not be rent stabilized, but that sentence at the top of your lease is not self-effectuating. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.